Good morning, Mr. Rankin.
Good morning, Your Honor. May it please the Court, I'm Charles Rankin for Mr. Porro here on limited further appellate review. I'd like to try to set the stage for the Court's consideration of this issue. Porro was indicted on two different counts that are relevant to this issue. Assault and battery with a dangerous weapon to wit a car.
Okay, I have a question for you. If the defendant is indicted for assault and assault and battery, but the only evidence is of a battery, say that the driver hit the motorcycle, the only evidence is of a battery before the grand jury, would a McCarthy motion lie on an indictment of assault?
And your premise is that
He's indicted for both. Yeah, both
the assault concerns the same incident as opposed to the possibility.
Yeah, sorry, yes.
I think that would lie, Your Honor. I think if there is a factual basis for the completed battery, but not for the assault, in other words, that there's no theory of facts that's going to get a jury to acquit on the completed battery and convict on the attempted battery, then I think a McCarthy motion would lie.
So, in other words, you're saying that an indictment for assault and battery does not permit the jury to convict of less, unless there's separate evidence of less.
I think that there has to be a theory under traditional lesser-included offense jurisprudence that two things: a factual theory by which the jury could say we're acquitting on the battery but convicting on the assault, and this is important, that issue was in fact in dispute in the case. And here we say that there was no factual theory by which the jury could have found that the final swerve, which resulted in the collision, was merely an assault. And we say that there was no dispute about this by either side, by any witness at trial, and thus it was improper to have given the lesser included.
So there was no dispute that there was a battery, that the car hit the car and motorcycle collided.
There was no dispute that the car and the motorcycle collided, causing the man serious injury. The dispute was whether the swerve, the final swerve, was an intentional striking of the motorcycle and the motorcyclist, or it was trying to merge into the left lane and accidentally striking the motorcycle.
Well, I just have one more question. Why did the appeals court decide that a retrial was necessary when there already was a conviction on assault with a dangerous weapon, and they say no error?
No, I'm sorry, Your Honor. That's not what the appeals court said. The appeals court said that it was improper to have convicted him on assault with a dangerous weapon unless you limited the jury's consideration to the final swerve. And because of the possibility and, in fact, overwhelming likelihood that the conviction of assault with a dangerous weapon rested on an earlier swerve that did not lead to the actual collision.
Yeah. So what you're saying, I think, is that you can't have the fact that an assault and every assault and battery has within it an assault does not mean that every assault and battery allows for a lesser included offense.
On these facts.
Because if the battery is completed and there's no dispute about that, you can't just sort of freeze the camera a minute before and say, oh, well, even if that's problematic, we've got what was already there.
That's exactly
well,
right.
But you can say there's a charge of A and B DW, and everybody agrees the defendant stabbed the victim. If the jury comes back assault and battery,
and how does the trial judge give an instruction on assault and battery if there's no dispute that there was a stabbing? If the defense was self-defense, it's either assault and battery or it's not. It's not, ABDW or it's not. It's not an assault and battery.
Justice Gantz?
Why is it not entirely reasonable for the jury here to be divided, with some jurors saying that Mr. Porro intended to strike the victim, and leave apart whether or not he had to strike his person or strike the car? Let's assume they were not troubled let's assume they figured that if his car struck his motorcycle, that was sufficient regardless if they struck him actually. And some of the jurors said, well, you know, I'm not sure whether he intended to strike the motorcycle or intended to scare the wits out of him, and that he intended to scare him, did not intend to hit him, but then he messed up and he actually hit him. So he didn't intend to strike him, he intended to scare him. Why is that not a perfectly sensible thing for this jury to be struggling with? And if that's the case, why is it not perfectly sensible for the jury to agree that, well, we can't be sure that he intended to hit that car, but we can be sure, we can all agree that he intended at the very least to swerve over and scare him, and so we'll find him guilty of assault?
Well, first of all, the scenario Your Honors hypothesized would in fact be assault and battery with a dangerous weapon, because it would be the reckless form of assault and battery. To swerve a car close to a motorcycle, intending to scare the motorcyclist but not to hit him, would fall within the recognized line of cases that says doing so is in fact not just an assault, but is an assault and
Okay,
battery.
but I gather there was no instruction given as to that to the jury, was there?
There was, well, the reason was because everyone agreed that if the defendant's action was intended to either scare or hit the motorcyclist, it was an A and B DW, or if it was accidental, then he was not guilty. There was no, I mean,
But
that's
the jury
precisely
would,
why
the
we have
jury
this.
would not have known, based on the instructions, that it had the alternative, as in my scenario, to say, well, that's still reckless and it's still A and B.
Well, and that's precisely why the court, in setting out the law of lesser included offenses, has said that the issue has to be in dispute. So, for instance, the Commonwealth tries to hypothesize a factual scenario to warrant retrial on attempted battery, and says, well, even though the law is that if you hit the motorcycle rather than the motorcyclist, that's a completed battery, here the jury could have been confused about that. Well, if the defense had argued that at trial, or even suggested it through cross-examining any witness, then the judge would surely have given an instruction of the correct law, and that would have removed that as an issue. And if the defense had suggested in its questioning that this was merely trying to scare off the guy who was buzzing him, then surely the Commonwealth would have sought an instruction, and the judge would have given it, on reckless assault and battery. So that's how the law of lesser included offenses has evolved, and that's appropriate. And to take those hypotheses that were not put before the jury because they weren't in dispute, and then to bootstrap that to say, well, it's permissible to try this man again, even though the Commonwealth had one shot at it is unfair and would violate his rights under the Double Jeopardy Clause, among other problems. So,
could the jury have disbelieved that there was a battery? Could the jury disbelieve that there was a battery, or believe there was a battery but didn't believe? I'm sorry. Could the jury have believed there was a battery but didn't believe it was the defendant's fault?
Battery?
An accident.
An accident, battery, accident, touching.
the jury could have believed that it was an accident, but the result of that would have been not guilty, I believe.
But why couldn't it have been an accident as to the battery and an intentional as to the assault?
Well, I think that is what I was trying to respond to Justice Gantz's question, and that would be a reckless form of assault and battery, where you're not intending to strike the person, but you're intending to get close to him to scare him off.
So, and you say that wasn't, the reason you couldn't go back to that is that it was never in dispute?
That was not in dispute at all.
That's not the way the case was tried.
I'm sorry?
That's not the way the case was tried.
The case wasn't tried that way. In fact, the defendant presented evidence in the form of an expert and questioning the Commonwealth's forensics expert to show that there was, in fact, contact between the car and the motorcycle. There was blue paint on the car. There was paint the color of the car on the motorcycle. There was rubber scratch marks on the from the handlebar on the car. The handlebar most likely pierced the rear fly window. So it was not a
But
case.
that's not inconsistent with finding a reckless form of battery, is it?
No, it's not at all. There was no argument and no suggestion in cross-examining or direct examining any witness, including the defendant, that I was trying to get away from him by swerving so that he would back off. I mean, there was...
Okay, but certainly if the prosecution had asked for that instruction on reckless A and B, they would have been entitled to it, wouldn't they? Because the evidence would have supported that.
I think that's fair. I think the judge would have instructed on that, and I think given the scenario, the factual scenario of the swerving, I think that's fair. But I don't think that leads to the propriety of giving the lesser included in this case because of the way the case was tried. There was just no...
To get there, I think, wouldn't you have to say, you would have to disagree with the proposition that the jury's coming back on the aggravated assault is implicit in that is an acquittal on the battery piece of this.
To be sure. And, putting this in context, it's pretty clear what happened. There were two charges, the ABDW aggravated by motor vehicle and the assault dangerous weapon. And there was evidence that earlier in this encounter, the defendant, who was a special agent of the Commerce Department, had this verbal dispute with the motorcyclist, became concerned because of threatening words from the motorcyclist, and pulled out and put on the seat a revolver. And so the second day, and various witnesses described that differently, but in any event, on the second day of deliberations, the jury reported to the court that had achieved a verdict on that count and was deadlocked on the ABDW motor vehicle. And so the judge accepted the verdict on that, finding him not guilty on the assault dangerous weapon, to wit a gun, and then gave a Tui Rodriguez charge on the ABDW. The following day, they came back and said, can we consider assault dangerous weapon car? And at that point, we said, well, no, you shouldn't do that. The defense said, no, you shouldn't do that because it's not the way the case was tried, it's not factually warranted, and there's no rational view of the evidence supports it, and you have to limit it, if you're going to do it, to the collision itself. And the judge made it clear that she was not going to limit them. She wasn't going to itemize a verdict slip between the earlier swerve and the collision, or between attempted battery and threatened battery. She was just going to give it to them. The most reasonable reading of this record is that they convicted the defendant of assault dangerous weapon based on the earlier swerve, because there was a lot of evidence of the earlier swerve from various witnesses, the parties and disinterested witnesses. And so rather than parse out some remote hypothetical that would have warranted giving the instruction to the jury, a fair reading of the record is that the jury convicted him on ADW motor vehicle for which he had not been indicted. And the reason we know he wasn't indicted is because the ABDW motor vehicle that he had been indicted on was the aggravated form, and the aggravated form was only as a result of the collision that seriously injured the motorcyclist.
Are you saying that the appeals court was wrong when it said that the jury could have said, we don't know in the ultimate incident who was at fault, but that in the course of these dangerous swervings that led to the battery, one of these was an assault? You're saying that's wrong because that would have had to be the reckless form of assault and battery?
Yes, as Justice Spina and Justice Gantz were discussing. And, the Commonwealth tried to take what I consider or suggest was the appeals court shortcoming in coming up with some factual scenario to justify the assault factually, and said, well, you can justify it by saying that the jury may have had concern about touching the motorcycle as opposed to the motorcyclist. And I think that I tried to address that a moment ago.
Now, there are many, many cases, of course, in which a person pleads guilty to a lesser included, even though there's no dispute in the facts that he was guilty as to the more serious crime. Are you saying that that can happen?
I don't think a decision in this case, as I'm urging, says anything about whether the parties can agree that a plea to a lesser included offense is appropriate. I mean,
And if it's appropriate then to be done by plea, why would it not be appropriate to be done by a jury?
because
Why can't a jury, for whatever reason, perhaps leniency, or say, we don't want to find him guilty of all that he arguably is guilty of. We want to find him guilty of a lesser included.
Well, you know, Judge, it's interesting reading the case law about lesser included. Typically, the issue comes up when the defendant has been convicted of the greater offense and is complaining that the trial judge refused to give a lesser included instruction. Right. And the court has been quite rigorous in saying that there has to be both a factual basis for acquitting on the greater, convicting on the lesser, and it has to have been in dispute at trial. And you know, the court got closest to this issue in Thayer, where it took an appeals court decision that had reversed a lesser included conviction, and on further appellate review it said, no, we're reinstating the conviction. And the language of Thayer was perhaps not as precise as one would hope, and it suggested that the jury could have just simply disbelieved the complainant's testimony on a particular issue. And when that was presented to the court later in Donlan, the court clarified that it really did not mean to say that simply the reason to a jury's decision to disbelieve a part of the complainant's testimony is not good enough. And in fact, in Donlan, there was dispute at trial about whether force had been applied that was manifested during the cross-examination of the complainant by the defendant. And so in Donlan, it kind of explained that we didn't mean what you're suggesting we meant in Thayer.
Thank you, Mr. Lankin.
Thank you, Your Honors.
Good morning, Mr. Lynn.
Good morning. May it please the Court. Paul Lynn for the Commonwealth. The first thing I would like to say is there's a suggestion in the defendant's reply brief that we are asking this Court to overturn the Morey rule. I want to emphatically say that if there's one thing that defense counsel and I agree on is that we want the Morey rule to be upheld. The only question here regarding the threatened battery theory of assault and battery is whether or not it is a very narrow exception to the Morey rule based on the fact that it has peacefully...
But did you argue about the threatened battery below?
By below you mean...
At the trial.
At the trial, no. I mean, my brother is absolutely correct. The defendant argued that this was entirely accidental, that he was just suddenly realized he was in the right turn lane. He got over. He thought the motorcycles were behind him. The Commonwealth argued, this was an intentional battery. He got fed up with the motorcyclist. He pulled over. Everyone said it was a sharp movement to the left. He's guilty on that theory. So there's no question that the theory is raised by the parties at trial were simply yea and nay.
I have a question about the appeals court decision. The appeals court says that the judge's refusal to limit the instruction to the final swerve created a substantial risk that he was convicted of a crime for which he wasn't indicted. Therefore, there has to be a reversal, preserved error reversal.
Correct, which the Commonwealth conceded.
Right, and you can see that. But then why does the appeals court go on to say that the Commonwealth can retry him on the lesser included of assault by means of a dangerous weapon under the attempted battery theory?
Because the evidence supported all the elements of that crime.
But the evidence that the appeals court says the defendant claims would make out a reckless form of assault and battery, and there was no instruction on such.
It would suffice to, but it wouldn't necessarily lead, as I believe my brother even acknowledged when he was answering Justice Gant's question. And so I think that certainly the jury could doubt whether or not this was reckless. They certainly they could have found, if they'd been instructed on that issue, that it was nonetheless a reckless assault and battery, but they didn't have to. The jury is always free to reject evidence and find the evidence doesn't prove the case beyond a reasonable doubt.
How would they, I'm still confused as to how they would find the battering having happened,
Yes.
no question about it, serious injuries having resulted. How would they find, where do you stop the frame in order to get an assault by means of a dangerous weapon?
The Commonwealth's position is you don't need to stop the frame. And we point in this case to Chambers, in which a justice of the Superior Court said there was no battery because there had been no touching.
That was an erroneous interpretation of the law.
Absolutely.
So are you suggesting that we send this back and have the judge instruct erroneously?
No, of course the judge would not have to instruct erroneously in this case because there's no question. There's been a not guilty on the assault and battery. The only thing the judge would have to say is that we're trying this person based on the fact that he intentionally tried to strike the defendant. The fact that he struck him is no longer relevant.
Why isn't that a double jeopardy problem?
Because he was convicted of assault. He wasn't acquitted of assault. He was convicted of assault.
But you can only have a conviction, I think, on a lesser included if the evidence supports it. And the evidence doesn't support it here because everybody agrees there was a collision. How can you have an assault by means of a dangerous weapon? How can you have an assault by means of a dangerous weapon and
When you
not
have
an
a
assault and
battery.
When you have a battery. I asked the question, that's my first question, I think, one of them, that there was no disputed trial that there was a collision.
Well, it's exactly the same situation as you had in the Smith case earlier this morning. The fact that the battery actually occurred doesn't necessarily mean that we have to charge the defendant that way or the jury has to convict him that way.
How did the case
You did charge him that way. You charged him with assault and battery.
Oh, we certainly did, yes.
And you can only get an instruction on a lesser included if the evidence would support the lesser included. How does the evidence support assault by means of a dangerous weapon?
I think what you're saying is there is case law, most notably the appeals court's decision in Commonwealth versus Ortiz, that you cannot have an instruction on a lesser included offense if there's no dispute as to the element that distinguishes it. There's no question that the evidence supports, as a matter of law, a verdict of assault. The jury clearly could have found that the defendant intentionally tried to hit the victim. There was no dispute that in that attempt he actually succeeded.
The Commonwealth could have charged simply assault.
Absolutely correct.
And the fact that there was a battery would not have
been a defense to that.
But how did the case get? Why was the case submitted to the jury on a lesser included offense?
It was not submitted to the jury as a lesser included offense.
How did they come back with a lesser included offense?
Because, as my brother pointed out, they had been given the instructions on assault with regard to the firearm charge, assault with a firearm. So they knew they had the law before them, and they were sitting in deliberations, and they said, hey, wait a minute. I mean, I'm speculating here, of course, but hey, wait a minute. Why can't we apply this law over here to this charge? So the only question is, where the case was submitted to the jury on a yea or nay theory, but the jury came back and said, we're concerned about, whether or not the Commonwealth has proved all the elements of this crime.
They were deadlocked.
Right.
Okay.
Well, I mean, we don't know that they were deadlocked. They just wanted to know.
No, they had said they were deadlocked.
Oh, yes, excuse me. Yes, they did say earlier they were deadlocked. So, I mean, it's certainly...
But the jury was not. The jury was told they have to find to find him guilty of assault and battery, the jury was told you must find that he intended to hit him.
Correct. That was how they were instructed.
The jury didn't know that reckless was enough.
No, they certainly did not.
But they knew that reckless was enough with regard to assault.
They weren't told
putting in
that.
fear was enough.
Putting in fear was enough for an assault,
Okay.
yes.
And is it your position on retrial that the jury can get both theories of putting in fear or attempted battery, or just attempted battery?
The Commonwealth's theory is that the jury may be instructed on both theories. I would point out...
That's your exception to the Maury rule, even
yes,
though
exactly.
Separate
right.
elements.
Yes, there's
elements.
no question. It does not fit within the Maury framework. The Commonwealth's basis for arguing that it is nonetheless a lesser included offense of battery is that these two rules, Maury and the rule that threatened battery is a lesser included offense of battery, have coexisted peacefully for over 100 years.
So I take it what you're saying is what should have happened is that there should have been a hung jury on this thing, but the jury exercised its nullification powers and came back with a lesser included.
It's not clear that the jury exercised its nullification powers. They certainly could have come back, as I say, either confused about the definition of touching, or as on a theory of threatened battery, as they had heard it regarding the firearm charge. So it's not. I'm certainly not conceding that this was just a compromise verdict.
Do you agree that by coming back with the assault with a dangerous weapon, they have impliedly acquitted on the assault and battery?
Oh, absolutely.
Okay,
There's no way that they. Yeah.
All right, if we agree with what you say, I'm not saying we do or I do, but if we agree with what you say, how do we know that the jury did not convict on the earlier offense, the earlier, when there was just an assault and no battery? Maybe they did convict on that, and therefore they would be convicting on something on which the grand jury didn't indict.
That is a possibility.
And so since there's that possibility, don't we have to
Well, the appeals court rests its decision on that possibility, doesn't it?
To reverse, yes. Yes.
Yes, but since, that's what troubles me about why the appeals court says there can be a retrial. Since there is a possibility, and you concede such, that the jury convicted on the earlier offense, then doesn't the case have to be simply reversed without a retrial because there is a substantial risk that he was convicted of a crime for which he was not indicted?
No, the Commonwealth relies on the law that where there are two theories that the jury could have convicted the defendant and the evidence only supports one, that the defendant can be retried on the theory that the evidence
but
supports. But
certainly it's more likely the evidence supports only one about the earlier swerve. The evidence really doesn't support only an assault with regard to the second.
Again, I would say the evidence absolutely supports the verdict. It's the elements of the charges as there was defined of them.
Not if it's you agree it's an acquittal on the assault and battery dangerous weapon. The evidence doesn't absolutely support the verdict.
Oh, it does. There's no question it supports it. The evidence supported. I mean, it's also, we're not disputing that the evidence that they could have found the defendant guilty of something he was not indicted on. And if that's the end of the issue, that's the end of the issue here. That's if this court were to rule that precludes the Commonwealth from retrying the case.
Well, have we said that in the past? That if there were two incidents on the same day, and it isn't clear on which the jury came back, that it wasn't clear on which the grand jury indicted, then you can't convict the defendant.
What we conceded below was that because there was a possibility that the jury convicted the defendant based on uncharged conduct, the conviction had to be reversed because, of course, the defendant has to be convicted as he was charged. But the Commonwealth takes the position of where there is a supported theory and an unsupported theory on which the verdict could have been reached. The law has been reasonably clear that the Commonwealth may nonetheless, even though there was a possibility that the jury convicted based on an insufficient theory, that we can still retry the defendant on the charged theory.
You're saying that if there was a mistake, it was the jury that made the mistake. The Commonwealth presented evidence to the grand jury, specific evidence that supported this charge, or at least a charge of assault and battery by means of a dangerous weapon, and there's no way of knowing whether the jury focused on that.
Correct.
And evidence was presented to support that charge at trial as well.
Yes, before both the grand jury, yes.
They acquitted on that. Assault and battery.
No, well, they acquitted on assault and battery. They convicted of assault. If I may answer Justice Spina's question, certainly the evidence presented to the grand jury was essentially identical to the evidence presented at trial with less detail, of course.
And Mr. Lynn, is there any question that the Commonwealth was really proceeding on the A and B charge in connection with that final swerve?
Oh, of course. There's nothing else. There was no other contact. That was the only thing that we could have possibly proceeded on.
So if you
So the
had
assault
this,
piece of that is really, I mean, it's not irrelevant, but it's largely irrelevant.
Well, I think the best way to answer that is to, again, answer Justice Spina's question. The evidence before the grand jury obviously sufficed to establish that the defendant intentionally swerved over to hit the victim with his motorcycle.
Or to do something to the victim.
No, well, yes, but it also certainly supported that he was reckless, that he swerved over and recklessly swerved over. It supported the hypothesis that he intended just to hit the victim or just to scare the victim and accidentally hit him. And it also supported the theory, supported all the elements of an attempted battery. It just simply supported the additional element of a completed battery.
Did they get a written jury verdict form?
Yes, but the verdict just, I would have to look to remind if there was even a spot.
I mean,
assault.
didn't the judge get a clue or something like that when they came back and announced their verdict, that they were coming back with something that they should not have come back with?
Well, she gave them an instruction.
She gave them an instruction.
Over the defendants, if I may say so, screaming objection.
Oh, yes, screaming, and I think screaming is actually probably too
Mild.
harsh on him. It was a beautiful objection that brought all the problems to the judge's attention.
And she paid no attention to them.
Yes.
I mean, not she paid no, she paid attention to them, but she disagreed with them and
Yes.
sent it to the jury.
Yeah.
If you had just, let's just say the original instruction on aggravated ABDW is given. Jury says, we're deadlocked.
Yes.
Retrial.
Mhm.
On that retrial, you would say, you think you would be able to say to the judge, we want instructions on assault and battery with a dangerous weapon, and we want instructions on assault with a dangerous weapon, based on the final swerve that hit Mr. Merlongi.
Yes.
Because
The evidence supports the elements of both of those charges. The question is how strictly this court is going to interpret Ortiz, the disputed element, because certainly the evidence, as a matter of law, supports.
Well, sure, every assault and battery has within it an assault, so it always supports.
Exactly. So the question is, the Commonwealth would not have that happen. I imagine we would not have requested, neither would the defense have requested a lesser included offense, because we wanted to prove the theory. We wanted to prove the case on the grounds that the defendant intentionally swerved and hit that person. That was always our intent. I don't think anyone was thinking about lesser included offense, and certainly wouldn't on a retrial, until the jury suddenly came back and said, how about this lesser included offense?
Am I correct then that implicit in what you're saying is that the absence of the battery is not an element of the crime of assault?
That's exactly what I'm saying, Your Honor.
It's unlike some of those cases where a judge gives a lesser included offense instruction over the objection, over the defendant's objection, and the jury comes back with a conviction on the lesser included offense when there's no evidence to support the lesser included offense.
There's the case law goes both ways on that, and I think that's one of the things this court needs to resolve as to whether or not, where there is no disputed offense, that it is actually an error of law for the jury to come back with a lesser included offense, even though that's supported by the evidence.
Isn't that a little tough on defendants?
How so? I mean, specifically.
Well, because you're not. The evidence may support it, but the defendant is not focused on. That's what I've got to push back on.
It is a problem, but the court is.
I mean, what we try to do is tell defendants, this is what we're going to try and find you guilty of. That's what we try to do, and we try to make that abundantly clear, so that the defendant will know what the defenses are that he can or she can present to those charges, and all of a sudden you get another one.
Right, and that's why the issue of lesser included offenses requested by the parties has to be addressed in the charge conference. So the defendant knows, when the defense counsel knows when he stands up to make his closing argument, what he's doing. But there is a particular problem when the jury requests it by itself.
Mr. Lynn, you've been around a long time. Have you ever seen a case where neither the Commonwealth nor the defendant asked for a lesser included, and this smart jury comes back and says, whoops, why don't we convict him of this?
I never have, and hope never to again.
So we could make up any law we want to, and it's not going to mess up the Commonwealth's cases.
I wouldn't go quite that far, but yes, it is a very unique situation.
I have a question about Ortiz, which you mentioned, an appeals court case. In Ortiz, there was the charge was rape. It was oral intercourse. But the appeals court said even if the jury found that the complainant had implicitly agreed to fellatio, the jury could find she had not consented to being beaten up or being dragged about in connection with it. So there, an assault and battery was all right as a conviction because there was a dispute whether she consented. And if the jury found that she consented, she certainly didn't consent to being beaten up along with it. So therefore, there was an assault and battery. So isn't Ortiz different?
Oh, Ortiz is absolutely different.
But you just said it depends on how strictly we're going to apply Ortiz.
Let me rephrase that. That's a very good question. There's language in Ortiz which the appeals court applied that said emphatically that where there is no disputed element, it is absolutely error for the jury to find a lesser included offense, and that's what the Commonwealth.
Yeah, that's Mr. Rankin's second requirement. Thank you, Mr. Rankin.
Thank you very much.
All rise. Hear ye, hear ye, hear ye. All persons having anything further to do with this